Hi guys. So abhi recently Supreme Court has done is it has overturned the previous decision taken in the Jharkhand Mukti Morcha's case. अभी न्यूज में चल रहा था तो I thought of coming live and discuss this basic aspect what the Supreme Court has done and how it is going to be beneficial for the entire country in the long run. तो सबसे पहला क्वेश्चन तो जो है वो ये है कि आवाज ठीक आनी चाहिए so that we could continue. Now, the basic issue what I'm talking about is कि there are few countries including this US. अब हम लोग क्या करते हैं न्यूज़ में देखते हैं सुनते हैं कि there is political lobbying which is going on in many of the countries and in India also there have been certain incidents where the parliamentarian including the Rajya Sabha members, the Lok Sabha members, they used to take money to vote on certain issues, to on vote against or in favor of certain bills. एट द सेम टाइम अभी महुआ मित्रा का केस हुआ था थोड़े टाइम पहले, तो उसमें भी यही चीज़ आई थी कि महुआ मित्रा के केस में कि किस तरीके से क्वेश्चन पूछे जा सकते हैं एंड दैट टू रिलेटेड टू द बेसिक दिस ऑफ नेशनल रेम्युनिफिकेशन कि लोग पैसे देते हैं और पैसे देने के बाद लोग बोलते हैं कि भई आप जो काम कर रहे हैं, जो आपको क्वेश्चन्स हैं वो रेज़ करने चाहिए। सो लेट्स टॉक अबाउट दिस फर्स्ट एस्पेक्ट। सो इन 1998 देयर वाज़ दिस केस जो आया था दैट वाज़ पीवी नरसिम्हा राव वर्सेस स्टेट ऑफ सीबीआई एंड द सीबीआई। इट वेंट आउट टू सुप्रीम कोर्ट। इसमें भी इश्यू यही था कि देयर वर सर्टेन पार्लियामेंटेरियंस, एमएलएज़ एंड एमपीज़ जिन लोगों ने पैसे लेके उनके ऊपर एलिगेशन थे कि उन्होंने किसी एक बिल के फेवर में वोट किया। And the Supreme Court held that based on the Article 194 Clause 2, they are immune to such kind of prosecutions. So वैसे तो Prevention of Corruption Act जो है that is applicable upon each and every government servant. But Supreme Court का ये जो decision था that gave the immunity to all the political parties, all the politically influential people, including this the MLAs and the MPs. अब सुप्रीम कोर्ट का 1998 से जो चल रहा था वो अब तक चलता रहा और चलने के बाद अब इन 2014 some lady named Sita Soren, a member of Jharkhand Mukti Morcha, was accused of accepting bribe to cast her vote in favor of certain candidate in Rajya Sabha, basically election 2012. After that, the CBI got the one FIR registered against her. In 2014, she moved to this High Court, Jharkhand High Court, and this High Court, Honorable High Court, was pleased to dismiss the quashing petition against the charge sheet, and the matter went to Supreme Court. So basically, the claim at that point of time by Sita Soren was that she enjoyed legal immunity by virtue of Article 192, and especially in view of the case laid down, the case of PV Narasimha Rao versus CBI in 1998, the Supreme Court's decision was affecting her rights. So basically, gave her the rights to to do whatever she wants. अब प्रिवेंशन ऑफ करप्शन एक्ट में 7 साल तक की जो जेल है उसका प्रोविजन होता है, बट लेकिन जो हमारे एमपीज और एमएलएज हैं उनके अगेंस्ट इस तरह का सिचुएशन नहीं हुई। So that is why the Supreme Court in 2014, the two judges bench referred this matter to a three judges bench. In 2019, the three judges bench headed by Justice Honorable Justice the then CGI Rajan Gogoi. Ranjan Gogoi noted that the decision of PV Narasimha Rao's case in 1998 was directly dealt with this issue, but it was referred to the larger bench because that was a larger bench issue, and this should have been decided by a larger bench because it involved a substantial question of public importance. So in 2000, basically in 2023 or so, September, five judges bench, which was headed by the current Honorable CGI Justice Chandrachud, doubted the decision of PV Narasimha Rao's case in 1998. So this matter was referred to further larger bench. Now this is the seven judges bench which has actually held. Now, why this was what was that in the 1998 case which we actually required consideration. So The 1998 case of P.V. Narasimha Rao ruling that involved 1993 Jharkhand Mukti Morcha bribery case. It was basically against the Jharkhand Mukti Morcha chief and former Union Minister Shibu Soren, the father-in-law of Sita Soren. The petitioner in the present case जो अभी चल रहा है हमारा, and Mr. Soren, along with some of his party members, were accused of taking bribes at that point of time to vote against the no confidence motion moved against the then Prime Minister R.P.V. Narasimha Rao and its government. So, two of the judges of the Constitution bench opined at that point of time that by virtue of Article 105, sub Article 2, and Article 192, sub Article 2, that this they had the immunity to vote in favor or against any motion. But most of the judges at that point of time, they observed that although they were acutely conscious of the seriousness of the offense, such sense of indignation should not lead to narrow construction of the constitutional provisions, as it may result in impairment of guarantee of parliamentary participation and debate. So the top court, what it has ruled as of now is now the parliamentarian in this case, the court emphasized that the offense of bribery is complete at that point of time when the legislator basically accepts the bribe, whether or not it is followed by or voting or making a speech in manner warranted by the giver of the bribes. Equally, a place where the bribe was offered or received did not matter. Now, this verdict says that Section 7 of the Prevention of Corruption Act strengthens such an interpretation since it is expressly states that obtaining, accepting, or attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of public duty by a public servant has not been improper. So, after this, I think this lobbying in India is going to stop. I think this entire thing is going to create a good accountable government. और आने वाले टाइम में हो सकता है कि जो हमारे क्वेश्चंस हैं जो बेसिकली जो बड़ी बड़ी पब्लिक कंपनीज हैं या फिर कोई इन्फ्लुएंशियल ग्रुप्स हैं दे विल नॉट बी एबल टू पे दैट मच अमाउंट ऑफ मनी टू द member of parliaments because they will again be susceptible to the penal action.